Trial Lawyers University, where the Titans come to train. Produced and powered by LawPods.
Well, we got David Sugden here, and David's an unusual guest for this podcast because he is not a personal injury lawyer. He is a business torts lawyer, which, you know what? When you think about it, it sounds like not a bad idea because corporations, they got a lot of money when they get a judgment against them, whereas sometimes individuals don't. There's not a lot of caps on damages in these egregious business torts, I'm guessing. Would any of that be true, David?
It's absolutely true. No, and the principles are the same. You got to put on a case where you're telling a story that appeals to the jury, and the principles in a PI case and a business case are the same.
Because, I mean, in every kind of breach of contract, you still got that same element of betrayal. The trust. I mean, nothing worse than trusting somebody, and then they just jack you. I mean, it's like, I'm going through that with Caesar's Palace right now. We're doing this big conference there. We said we're going to have outside AV, and then they're like, oh, you have outside AV, but you have to use all of our in-house union people, and it just adds an astronaut of money, but it's like, that was obvious what we meant, but then they use this little rope-a-dope around the corner. But you know what? Another valuable lesson learned. Never had that happen before. So I could take it like, ooh, it hurts for a little bit, but then it's like, oh, wait a minute. I got rope-a-doped. That happens when you do with businesses that are always, just only very transactional, but that's okay. So David and I got connected because I was with Giorgio and we were talking about the conference, and he's like, somehow your name came up, and he's like, I've watched a lot of his videos and they've really helped me a lot. I'm like, really, tell me more. Because anybody that would take the time and the discipline and the energy to actually try to, whatever the topic may be, to sit down and articulate their best thoughts and practices with the intent of giving somebody else the ability to do it, is a tremendous effort. The quality of it, the use is really secondary to me. It's the effort put in that's primary, because it takes such effort. And the stuff that he was telling me you were doing was so fundamental because, I remember as a young lawyer, getting outmaneuvered on the rules of evidence and procedure and how much that stymied me and objection, foundation. I'd try to slay a foundation, objection, foundation. I mean, judge, what am I missing? Mr. Ambrose, I'm not here to teach you how to practice law. Right. Okay, there went all the credibility with the court, with the jury, everybody. I'm like, that's not a good way to start out, but that's what happens. And then even older, you know what I mean? I'm just getting, I've been doing this conference for a few years now, and only had one trial, and I'm, looking to get really back into it as soon as this conference is over, because I have 8 months until the next event in Huntington Beach. And that one's more predictable because it's the same hotel for 4 years in a row. And so it's just, keep improving upon this, what we did last year. And what we did last year was really freaking great. If you ask anybody that was there, and it was right in your hometown, right near you. You didn't stop by though, Mr. Big Time. Don't worry about it though. We didn't hold it. We will not hold it against you this time. You don't show up next year, it could be a problem, but anywho. So you made a set of training videos, as you actually, and you sell these training videos, but I also find, the entrepreneurship of a stodgy business lawyer, I was also impressed with. So tell us a little bit about these training videos you made.
Sure. Well, the genesis of them is sort of similar to what you just described. In other words, that nightmare fear that we have as trial lawyers, where you're in trial, you have this key piece of evidence that you want to get admitted, and for some reason there's an unexpected objection, the judge sustains it, and all of a sudden there's that nightmare where we're flat-footed and we don't know how to navigate around that. And so I just realized that as a young lawyer, I need to not just understand what these rules are, but how do they actually get applied in trial? How do I use the evidence rules as a tool and be competent? And then the more that I did it, I realized that it's not just knowing these tools and how to execute them, but if you know them well, they end up being tools of persuasion, where not only are you able to really deftly navigate evidence, but what happens is the judge recognizes, oh, you know what you're talking about, you know the rules, and all of a sudden the judge will be a little bit more deferential to you when you're making an objection or navigating it around an objection. And the jury picks up on all of that, where all of a sudden they realize that side of the room has competency is telling the truth, knows the rules, playing by the rules. And so then I realized that the courses that I put together are, in essence, the courses I would have liked to have watched and found as a young lawyer, and I just didn't. I just didn't find them. And so then I ended up, I would go to the odd conference, do it live, and then just by virtue of a number of factors, I realized I can put these together as online courses and just put them out so people can learn what I've learned.
And when you talk about things you wish you would have known, I had like so many people say to me on a regular basis, "Man, if I'd only had this stuff when I was younger, what I could have become." And I'm like, "Me too." I said, if I don't have the stuff when I was younger, I guarantee there'd be no TLU. I guarantee it, because I would have made a lot of money and had a very comfortable life by the time I was 35. And Nick Riley wouldn't have nothing on me. Let's put it that way. If I would have had access, I worked my ass off. I went to many conferences a year. I was a criminal defense lawyer. I didn't make a lot of money. I mean, I probably made $60,000, $75,000 in a good year. And I was spending probably 10% of my income going to, NACDL, going to any, going to Michigan conference, going to any conference. I could go into trial lawyers college. I went out there every year, for 12 years, for 2 or 3 weeks at a time. And people are like, "Man, you must be the slowest learner there ever was." I'm like, I must be, because, and I never got, but people are, "You got staff?" I'm like, "Nope, 12 years in a row." But in hindsight, that was the greatest thing they ever did to me, was that rejection, because, you so desperately want to be accepted when you're young, and you're around these great, what you perceive to be as great lawyers. And, they're doing a lot of weird shit with the psychodrama and the crying and all this stuff. But like, you're totally bought in. You're like, this is the way. And, you work really hard on it, but you're just not accepted by the powers that be. They just haven't anointed you as, teacher and anyways. And so it was an experience, but it was a really positive experience. And it really taught me that, what, there's a lot of this is not teaching. Once I understood what Jerry Spence really did, once this guy, Dave Clark, who's my mentor, who lives out in Omaha, who broke down, Jerry's like, I went out there like in 2000 and maybe 2014, and studied with him for many, many weeks. And, when he broke down to me all the elements of what Jerry Spence really did to win, the Milton Erickson conversational hypnosis, the NLP, the embedding of stories, the high-level rhetoric that they never talk about because it's so manipulative. I'm like, manipulative? We're all manipulative. We start manipulating people when we're fucking get bored. We start crying. That's manipulative. I mean, if you ever have somebody work for you, you start, have to like tell them something they did wrong and they start crying. It's like, what the hell is going on here? I mean, it's like shocking, but it's like, so that's when I kind of lost a little faith in the operation, when it's like I realized that everything, that most of the stuff they were teaching there was not what Jerry was doing to get the big verdicts. It was like, I mean, it was great for personal growth and making friends and getting connected. I mean, come on. It's like summer camp for lawyers, bonfires, drinking, there was a fair amount of, what's that word, philandering? I don't know if that's the right word or not, but a fair amount. You can imagine people get away from their homes for 3 weeks for the first time in their lives. Like, because these people were having a different experience than me, because I didn't have that kind of like, whatever. I just loved going out there. It was a lot of fun. So, but the purpose of learning, sorry about that sidetrack, the learning. So tell us, because, I really built with this TLU stuff because I wish I would have had this. And that's why we have like a whole bunch of law students coming this year. We got about 30 of them coming, because like, so they get access, because they have access to this stuff, what they could become with proper, guidance and training and mentorship. And you're going to teach some classes out there. And I know some law students are already signed up for those, and a bunch more are going to, because I have a meeting with them tonight. And these classes that you're teaching in Vegas, you're teaching two workshops. Tell us what those are and how people.
Yeah, so I'm teaching 2 workshops. The first is on hearsay. In other words, not just the law school, how to analyze a written exam on hearsay, but really how to navigate it during trial. And what I emphasize when we're talking about hearsay is, a lot of times lawyers will just sort of hear or see some writing that's out of court and sort of jump to hearsay. And the reality is that there are so many exceptions to the rule. The exceptions end up swallowing the rule. And so what I do is I provide tools so that the practitioner can identify in real time the ability of spotting what I call objectionable hearsay. In other words, hearsay that's actually worth objecting to. And then the other side of the same coin is, if you are trying to get a out-of-court statement in that you need to get in, and you hear that objection, you hear it sustained, how to quickly navigate around it. In other words, explain to the judge why it's perhaps not hearsay, or identify quickly an exception, and not just sort of the memorization of the written rules, but tools you can use within seconds to do it. The second one's on foundation. And again, so often that seems overwhelming to some lawyers in terms of how do I get this piece of evidence in? And among the reasons I like TLU so much, what you all are doing is because what you're doing is you're providing an environment where they can practice the skills they're going to do in trial, where it's just like sports. We actually practice the skill. And what so often happens with the rules of evidence is that practitioners will see someone in court not doing it right, not doing it correctly, and then they will come to the conclusion of, well, I guess that's how you're supposed to lay a foundation, and then this bad habit gets repeated. And so what I'm going to be explaining in this workshop is, number one, how to lay a foundation properly, and then we'll practice doing it. And then we'll also practice how to identify when someone's not doing it, to block the whatever, whether it's witness, testimony from a lay witness, a written document, expert opinion, sort of how to deal with all these sort of threshold issues you need to do that on the one hand it seems simple, but unless you have competence, you won't have confidence in it, and that can really affect your credibility at trial.
The confidence is the biggest factor, because trial is, like so similar to golf. To me, it's crazy because so much of golf is mental. You know how you're supposed to hold it. You know how you're supposed to turn. You know how you're supposed to swing. And occasionally, it hits a beautiful stroke. And you get that picture and it gets that feeling and you could just feel it. And you're like, God, how can I do that again? The next one, it dribbles off. But with golf, you get immediate feedback. With, trial lawyering, that's direct. I mean, it's clear, the feedback from that ball. Whereas trial lawyering, the feedback isn't immediate. It's not clear. There's a million reasons why you could lose a case or, win a case. And that's the challenge of training in this area, is because there really is no set determination of what you must learn, what you must be able to do, what you must know to be great. There's no, and so you just have to, I was reading that book, Peak by Andres Erickson. And, and I think he just mentioned Erickson. I'm listening to the book, The Talent Code, that you recommended. And he talks about, deliberate practice and, those areas of deliberate practice and, but the difficulty of deliberate practice to applying it to some things like consulting, which are very, they're not like golf or basketball or chess or playing the piano, which are really set skills. And there have been hundreds, decades, if not centuries of training on how to become proficient. So it's a little more challenging, this trial lawyering game. But also you talked about, when I was, constantly trying cases, everything I was like, okay, how do I get, what's the objection to this? Whatever the question is, and what's my response? For every question, I have a little note for like the rule, right? Because I got to take account. My brain does not work as well under high pressure. But the more things I can give myself to make it less, less work, the more likely I am to, to look reasonably comfortable. But the video series, let's talk more about that. So the different sets of videos that you actually have up and for sale.
Yes.
Tell us about those different sets and what the intention of specifically of each.
Sure. I agree with, so much of it does come when it comes to trial performance, the piece of confidence, and golf's such a great analogy where people can be great on the driving range, and then all of a sudden you get to the first tee, there's just a few people watching, and it all of a sudden seems that much more difficult.
Even with nobody watching, just the fact that it actually counts, the driving range and the tee box are just, they look the same. The ball's sitting the same way, but they're just two different worlds. It's the
I mean, the reality, we can have we can envision the world's best cross-examination in the comfort of our office, and yet when we stand up, all of a sudden our thinking is slower. And so the idea behind these courses is, what can we do because so often I think that confidence is a byproduct of competence. And so what can we do to make these people competent with the rules of evidence and sort of some of the laws of persuasion, so that when they go into court, they have that comfortability, which then the byproduct can be confidence. And so one of our first courses is just Evidence 101. And what we do is we walk the practitioner through the entire California Evidence Code from the beginning all the way to the end. And Again, what we do is not just say, okay, here's the rule, here's how to memorize it, but it's actually how to apply it. And it's right down to the basics. And it's similar to TLU, where you kind of get into the details of what does voir dire look like, and you kind of break it into the component parts. We do the same thing. For example, a lot of times lawyers will argue about whether or not something is relevant or not. And if you watch so many lawyers, they argue relevance sort of in a colloquial way, where they assume they've got to have this piece of evidence prove the ultimate issue. But what I explain is, no, when you argue relevance, you want to tie it to the actual language of the statute and use the phrase tendency and reason to prove and actually cite the statute, because it implicitly communicates to the judge, you know what you're doing. You're making the right argument. And so we do that all the way through the evidence code. And then the other class is deposition skills clinic, sort of the building blocks for when you are going to trial. And the idea is not only how to take a deposition, how to prepare witnesses for deposition, and then as backdrop to all of what we're doing in the deposition skills clinic is making sure that when you're getting that good testimony, it'll be admissible. Or when you're defending a deposition, you're raising the right objections to deal with the transcript when you're actually at trial. Because so much of my practice is coming into cases late, and a lot of times, you'll have good facts in a deposition, but you won't necessarily have good evidence. And so I want to make sure that our folks, a lot of times I'm told this is what happened. I'm like, fair enough, but we've got to make sure it's admissible. Then we have a class, Expert Witness Academy, and it's basically the same thing when it's coming to expert witnesses in terms of how to prepare witnesses, take expert depositions, deal with them in trial. And then our final, you don't have to take them in order, you can take them a la carte, but one of our classes is the Business Trial Academy. And it walks the folks through how to handle a trial from jury selection all the way to closing argument, and just kind of shows, and the theme is not just the rules of evidence, but what we explain is your role in a case is to be persuasive at every stage. And yet what persuasion looks like is really different depending on the stage of the case. In other words, in voir dire, you're looking to build a connection with the jury. You're looking to establish credibility. There are important principles in order to be persuasive. They first have to trust you before you start talking about the emotions of a case. And so I kind of walk them through the entire case all the way through closing argument.
That the whole trust factor, because I started doing these webinars, case analysis, and usually started out at, in March of 2020. And, it started out as being something to simply hopefully keep me occupied and, keep me somewhat connected, but it turned into a lot more. And, because I didn't get started in this, and I moved to California until I was like 45 years old. And so I was a little late to the game because I was a criminal defense lawyer. And it's very different, like the people that can transition from being a criminal defense lawyer for 2 decades and into a civil lawyer. I'm very impressed by those people, because the ability to grind out that discovery and all that written materials and all that procedural stuff is a lot of bandwidth grind that as a criminal defense lawyer, you never do it. And if you never do it, it's like, the worst thing you do is write a motion to suppress, which is a cookie cutter motion. You plug in a few new facts and boom. It's, if you got a good set, you might have a chance. Even when you do, most judges in the district courts, especially the DUIs and shit, it's like, ain't nothing stopping that breath test from coming in. I don't care about all there was some, they were all results oriented, but.
So I imagine with that background, you come to the civil space with a heads up when it comes to efficiency more than so many others, because so many young lawyers, they so much of their practice ends up being pre-trial work for upwards of years, and until you've actually been or seen a trial, it's sort of hard to make sense of, okay, what do all these things mean and what's the value? And so often when you have lawyers that don't have an eye towards trial, the litigation can just mushroom. It becomes like the Seinfeld. It's like a case about nothing, it ends up just sort of mushrooming without actually having the big picture in mind, which is, what is our objective here? Our objective is to either try the case well or leverage it in a position that we get a good settlement, as opposed to out interrogatorying the other side.
That's what the defense does. Their objective is to generate work, to create hours, to create time, to create, billables. That's their whole objective. the winning or the losing, and not to get fired by their masters. That's their objective, But it's interesting to talk about efficiency, because once you start doing this, because I could prepare like in most cases in a day, because I had set pieces of cross examination that I would use with every cop, set pieces of voir dire that were highly effective, like the presumption of innocence, burden of proof, reasonable doubt, convicting an innocent man, lying. If you talk about lying in your voir dire, well, you're clearly implying that the other side's going to be lying and they need to be looking out for it, right? But, obviously the ability to implant those, to get people thinking about that stuff in a case is very critical. But being efficient, because, especially criminal defense, so you're not getting paid very much. You get $5,000 for a trial. You can't spend, 150 hours on it. I mean, sometimes I did. I was not very good with the time management and the income relevance, but you got to be efficient. You and I discussed a little bit about learning, and you've studied learning and performance. And me, you, Shemek Lubecki, who's a very good friend of mine, and you haven't met him, but he also teaches with me. He's coming in Saturday because we're doing a boot camp this coming weekend for 4 days, Saturday, Sunday, Monday, Tuesday, the 4 days before the conference. I'm feeling ambitious. I'm like, everything better be done for the conference by the time Saturday rolls around, because I'll be a little focused.
Right.
But we're going to do a hour presentation on Saturday morning on performance and high performance in the courtroom. So tell us a little bit about what you know about high performance from being a trial lawyer and an athlete.
Yeah, and I've shared with you that among the reasons I really like what I do is, coming from a sports background, I played baseball in college, and similar to golf, there's a big mental component in terms of how to perform well. It's a team sport, but it's a team of 9 people taking turns individually doing something, and you have to do it well. And so much of the ability of performing well is having that confidence. And what I learned just from sports is just the equation of putting a lot of time in preparation and having the preparation done well, so that there's muscle memory when it comes to actual competition, the actual game. And in terms of how that translates to trial work, I mean, what I tell people is it physically feels the same. In other words, going into trial, it physically feels the same as getting ready for a baseball game in terms of the nerves and all of that. And so I've spent a lot of time, and I'll work with witnesses a lot in terms of how to navigate that and how to deal with when you have those nerves. What's that physical feeling that you have? And I'll often share that, number one, it's almost as though the body has its own mind, right? Where it senses this stressful situation, and you'll have this physical feeling, whether it's butterflies, heart racing, whatever it is. And because we want to create congruency, if we're not really mindful of our thoughts, our brain can send us really unhelpful messages. In other words, you feel this because you're not ready. You feel this because, it's all unconscious, but you feel this because you're not very smart, you're not prepared, or the judge won't, all these things. And just the ability of consciously recognizing that physical feeling, and then rather than listening to our thoughts, actually communicating to our thoughts. In other words, I feel this because I'm excited. I feel this because I'm ready. I'm prepared. This is important. A number of things, and realizing that physical feeling that you have, it's nothing to be afraid of. It's actually natural. It's a natural consequence of you caring about the outcome. And in many ways, it may give you the ability to be quick on your feet, to be thoughtful, and to be a good listener. All the tools you need as a trial lawyer. And so, a lot of times witnesses will say, "I'm so nervous." And I'll say, "Oh, good. So am I." That's a natural feeling. It shows that you care, and we can deal with that.
And so, but these nervousness and these feelings of insecurity, we deal with them. But how do we deal with them? How do you take this? Because you and I, like we talked about, I showed you a little bit yesterday. We met up. We're gonna do a webinar on one of your trials, but yesterday we didn't for a number of reasons. But we talked a little bit about performance in that. And so let's just take a young lawyer, okay? Let's just take a guy who, my nephew, Harrison. My nephew's Harrison. You'll meet him. He's a character. He's going to be DJing the closing party. But the question is, he's never done a trial. So how do you take a young person like that and give them a curriculum and a training system so that when they stand up in that courtroom, that they have confidence, that they're calm, because time slows down when you're calm, and then you can start to see the patterns when you're calm and you've trained. It's like there's an expression that the trained mind sees patterns where the untrained mind only sees randomness.
Yes, yes. Yeah, I think a great antidote to nerves is preparation, because the experienced trial lawyers, they're going to be naturally confident because they've got so much experience. It's just they know their competence. So the confidence is a natural byproduct. Well, as a young lawyer, you lack that. Okay, so what do you do? And I think among the things, you master the rules of evidence, you master the file. I mean, one of the advantages of being the young lawyer is that those nerves can be a great motivating factor, because you realize, I don't want that moment where I know there's an exhibit, I don't know where it is. You'll know the file better than the other side because you're more fearful. Okay, and then I think it's a lot of the deliberate practice. In other words, whether it's your opening statement. I mean, I just think.
Hold on. So you said deliberate practice, because that we talked about that a little bit. That has a particular meaning. So when you say deliberate practice, what do those two words mean to you?
Yes. So when I think of deliberate practice, you are just on the edge of your competency. In other words, you're not going to the driving range and just mindlessly hitting your 9-iron. Okay, what you're doing is, I'm not a golfer, but you're thinking like, what's the one shot I need to work on, and you work on that one shot very consciously, and you get feedback right away. And so, for example, I'm a big fan of mocking a cross-examination. And what you do is you mock the cross. And if it gets awkward, you stop, you analyze, you do it again, and you just sort of build that muscle memory so that when you get into trial, even though it's going to be a new experience, your first trial, it won't feel uncertain. There'll be a familiarity where you realize, okay, the witness is over there, I'm ready. I've tried these questions, and our firm has a courtroom that we've built, and the reason why is because you want to replicate the environment. So if you don't have a mock courtroom, even if you're doing a mock examination, mock it not in your office, not in a conference table, but where he or she is on the other side of the room, where you have to raise your voice, you have to speak in the same volume you're going to in trial, so that the reps that you're doing is as close to what it's going to look like in trial. And the more that you do that, again, the nerves, they'll be natural. But once you sort of get into it, you'll think, you know what, I think I am ready. I am competent. And I do know the file better than the other person because I've prepared more.
So as far as the golf analogy, for example, because I do practice, I need a lot more practice, but when I go out to the driving range, when you use a 9-iron, you pick a particular flag that you're trying to hit. How close to that flag every time? And can you do it consistently, right? Because you're right, you have to train on the edge of your comfort zone, but the other principles is like you have to have a coach. Somebody has to show you what to do, because these are complex skills, and to try to intuit, good freaking luck. Then you have to try the skill and get feedback on it. And then, you got to have a mental representation of what you're trying to accomplish. What does a good swing look like? What does a good swing feel like? And then when you do it, then you got to practice. You get a coach that gives you a lesson plan, and you're not with the coach, you're out there practicing, right? You got to put the time in. You got to put the reps in. You have to do the physicality of movement to, activate whatever amount of myelin is in your system that allows, your muscles and your mind and nerves, everything to react properly and to build those patterns. And it has to be something complex. You can't apply deliberate practice to shining shoes, or folding shirts. There's not complex enough a skill. And then you have to practice it under as close to similar circumstances as you can in a competitive network, competitive situation. And that's when you talk about practicing mocking your cross. I couldn't agree with you more, but the number of attorneys that actually practice it, like I've interviewed probably 40 lawyers on my podcast. And one of the things I often ask them is like, what are you doing to get ready when you get ready for trial? The only one I can really remember in my mind that says they actually, mock their cross-examination and have their associate play it is Rahul Ravapudi. And, it's so critical to build those patterns, on your cross. What's the pace? Doctor, you're board certified. I said, doctor, you're board certified. And your facial expression, your hand movements, your sequencing, all that stuff takes practice. And if you want to perform at a high level, how does anybody that, and there's really nobody that performs at a high level that doesn't practice. I mean, some of these guys just do reps in their heads and dream about it, and that's their way of practicing, and it works for them. And so, but for most of us, doing the physical work of performing is critical. It's just critical. I'm pretty stoked today because like later on, I'm doing a program with Spencer Lucas, and Spencer, he's a partner at Panish's office, and he's like a gangster trial lawyer. He came and did my boot camp. It was called Trojan Horse back in 2016 when I first started. And I had no idea who the guy was, but the guy already had like 3 or 4 8-figure verdicts. And he's in there, with me and like 10, 15 other people at this hotel in Marina Del Rey doing this boot camp. And then he got called out after a day. He had to go to trial. But we're doing a webinar today. And I consulted with him a bit on his last trial because it was supposed to be on this $135 million verdict. And, kind of go through the process of the training process of, what the TLU skills boot camps are like. And so I'm pretty stoked about that because, when somebody's got there on the top, but in their own way of figuring it out, or having Brian Panish help, mentor, the guy's like the greatest mentor because he's got, 8 lawyers that work with him. There, a lot of partners that got 8-figure verdicts, and they're all at the same firm still, which is amazing to me. Yes. You deal with lawyer egos. There's not too many people that keep that many egos in check, but everybody's a great coach. And then in Vegas this year, it's gonna be pretty cool because Panish, who I've known for a few years, met him through the pandemic, but him and Ravapudi and Shay and all those Lucas, they're doing their own track for 3 days where they just teach about, their methodologies and how they get the results that they do. And Sean Claggett, who's a much younger lawyer than, obviously he's like only 45, and he's crushing it. And, his firm's teaching how they put it together. Nick Rowley from, Trial Lawyers for Justice, Trial by Human, he's teaching for 3 days. And Joe Fried and Satch Oliver, they're really, big trucking guys. Satch just got a $140 million verdict a couple of weeks ago down in Rogers, Arkansas against Kroger. So he's gonna be breaking that down and teaching a lot, his speed, it's called Depositions, Our Trial. He just published a book. And Joe Fried, he's teaching for, 2 full days, which is amazing. 12 hours on speed trial, on trucking. Him and I are doing a presentation on cross-examination and, to help people start to see how to develop these skills, because there's people that never think about, it's amazing to think about trial. How many people think about, okay, how am I gonna perform this? Where am I standing with in relation to my exhibits? Where am I looking when I talk about my exhibits? How do I want my facial expression to look? How much of a chunk of information am I going to deliver to each juror? They never, this thought shit never crosses their mind. It's like when somebody talks to me and wants me to help them or consult with them, like on voir dire, and it's a month before trial. And I'm like, I'd be conscious, you might be too late because you're busy there's a million things going on. This is not the time to learn new skills, okay? You don't have the bandwidth. Most people don't have the bandwidth to learn new skills. And so you just got to keep practicing and practicing. But if we were to develop, because I think this is really important, and this is the part that I find most important, is to try to develop a curriculum, a program, a training program for not just young lawyers. Young lawyers, people are like, oh, is your program for young lawyers? I'm like, yeah, we're all baby lawyers, okay? Like, I'm a baby lawyer. I'm figuring my way out things called trial. There's so much to learn. And every day is so fascinating with all the people you get to meet. But to create a curriculum to train these skills on evidence, on, foundations, on objections, on, even how to object. Objection, people sit down, they don't get up, they say objection, barely break your head. Judge's like, what? It's like, what are you, a mouse? You know what I mean? And it's like, if you're not used to being authoritative in a public setting, you're probably not going to. If you don't practice doing it, in close assessment, you're probably not, just like on the flip chart, if you don't practice writing and, using a flip chart in your cross-examinations or any examination, when you try it for the first time in the courtroom, it's probably going to be illegible. Right. It's practice, right? And everybody's looking at it and they're like, what the hell does that say? The hieroglyphics? So like, how would you think about developing a training program to apply the elements of deliberate practice to teaching the skills that are fundamental and foundational for every trial lawyer?
Right. Well, I think what you all do at TLU is so important because it forces people to really think about the important details that are so often overlooked. For example, what you just said, just the way one objects is important. I totally agree because judges are humans too. And so they're picking up on the same communication things that we think about when we're talking to juries. I mean, I think the same principles apply. And a lot of times trials go so quickly. If you state an objection with uncertainty before the judge even goes through that analysis, he or she will be thinking, is this person right? What's going on? So just the ability of communicating that. And so I'm envisioning a program where we sort of marry the two. In other words, let's make sure that we sort of know the bones of the rules of evidence, and then let's put meat on those bones so that you're building muscle memory, so that when you make an objection, when you ask for a sidebar, when you offer to make an offer of proof, you're doing so in a way that you're not just sounding like you're reading a rule you've memorized, but you're doing it in a way where you're the one in the room that knows the rules. You're the one in the room where, and I always talk about, like, when you're talking to a judge, especially in pre-trial, you want to be really careful about coming across as too much of an advocate, okay? Because the judge wants to get the law right. And so if you can, in a way, communicate that you are right and you're helping the judge do his or her job to get this right, not get overturned on appeal, it's a huge advantage. It's a really helpful way. And so I think it's the same communication principles that you're teaching kind of married to knowing the nuts and bolts of the rules of evidence.
For me, it's, it's kind of like this whole situation is very exciting, for lack of a better word, because this is skills and information to me that I think, well, skills, not information. I can get the information by reading it. It's not doing me any good because I can't remember shit. But like the ability to get up and practice these fundamental foundational things. Another thing is like locking in a juror for cause. I mean, that's something people really never practice. And so when they do it, oftentimes it's sloppy and then they don't get what they want and then they get frustrated, right? But there's a best practices for everything we do, whether it's laying a foundation, whether it's, arguing a hearsay. And so really it's about, okay, first of all, articulating what are those best practices, and then creating a system or methodology to incrementally train the skills one at a time and break it down into smaller component parts so that people can get a lot of repetition of the same part over and over. And I think it's imperative that people are all doing the same thing, arguing the same hearsay rule one after the next, so they can learn from the person that goes before them. They're watching the person that goes after them, so they're in their minds, they could critique it. They can auto be correcting. That's why, like, the training program I did, I really, I've been doing it now for almost 3 years. And it's amazing when you do the same materials over and over and over, like the 3 voir dires that I teach, the 3 minutes of an opening statement, and the 1 chunk across. People are like, how many times do you think we've done these? I'm like, thousands? I really don't know, because it shows. The practice shows. And I can literally see and feel myself, and I record myself, when we do these programs, and then use my recording of myself to show people what to do, because they just saw it, but they couldn't really see everything in real time, but to slow it down for them through video, so that way they can wrap their heads around it. But then they got to get up and do it. And, it really, the thing that, obviously as a teacher, my goal is to transform the student, right? The only challenge I have when, somebody steps into this place right here, that's what I call my dojo. Usually the big TV right there, but it's on the other side right now. The only challenge is really how much can I teach these people? How much can I change their lives in this 4 days that they've trusted me with? But the critical part of that time here is what we do before we get here. That's the critical part, because, for one of my boot camps, we're starting one on Saturday, but there's, 6 weeks of preparation via Zoom, where I show them materials and they have to record themselves presenting the videos over and over. And I used to give them, written out script of the voir dire, but guess what that did? Well, guess what people did when I gave them that script, David?
You gave them the script.
So the script of voir dire, for like the script that we're going to practice
Yes.
at Huntington Beach, it goes, now we need to ask you all some questions.
Right.
About
Okay.
your opinions, your
I
beliefs.
imagine they either read it Or memorized it.
They memorize it. And so therefore they deliver the words, but there's no facial expressions, hand movements, voice, body, anything goes with it. It's just like, I mean, it's hard for me to impersonate it without like, now, I mean, without, it's like, now we need to ask you all some questions about your opinions. I mean, it was like without the hand movements, it's without the, the pausing, it's all different. But they practice that, and then we review their recordings, but they practice it little 20-second chunks, not a minute and a half, but 20 to 30 seconds. So it's a small enough piece, so that way, and then after they do it, they have to review themselves against the exemplar to see how they did, and then redo it. But just that act, the ones that, now half the people don't do that because they're lazy and they think that, nobody's going to know. But it's so obvious. And I tell them, like, look, you can do whatever you want. Okay. This is your time. This is your money. But my goal is to help you. I can't help you if you're going to do things at the last minute and you're not going to, put the effort in. You have to put effort in. This is not, schlock through it as fast as you can and upload some pile of shit video. Everybody's like, obviously you're not prepared. I mean, you're letting yourself down. You're letting down the group because we're all learning from each other, because we're doing a similar type thing. And with the evolution, because like as time goes by, the people that come here are getting so much better, so much faster, and which is obviously very exciting to me. But, especially when they get like results, you know what I mean? Like my, buddy Giorgio, who teaches with me, got a $25.5 million verdict with his mom last year. And they just resolved it at a mediation last week. And so, of course it's confidential, but it was a lot of, at least I consider it a lot of money. Now, a lot of people don't consider, $25.5 million or whatever, a lot of money, maybe Brian Panish, I think says that's a lot of money, but anyways, but confidence, not what it was resolved for. So, but that's what the verdict was, and that's always, I look at a verdict as always like a starting point of negotiations, right? Because when they're offering $500,000 and, you want 10 million, well, there's a little bit of a disagreement on valuation here. So that's why we got to have a jury figure it out. But the repetition that you do beforehand too, so people start practicing it and start doing that. Because like, in the next, few days, most of your classes are filled up, so you got to have a meeting with your students, try to, give them information so they can start thinking about the skills they have to have, right? Start preloading their brains. So when they get there, it's not like, okay, what's everybody want to do today? It's like, oh no, here's the plan. This is the way you do it. Get up and perform. Good morning, everybody. Okay, now get your ass up there and let's present. Let's not sit here and chit chat. We got, limited time. We got to make great progress in this limited time. That's the goal here. So we're looking, but besides all the great learning though we have at TLU, we have, the opening parties at Omnia nightclub on the terrace. We're trying to up our game a little bit. Then Thursday night, the party is an 80s party in the exhibit hall. We have a great band, and then Friday and open bars and lots of food. And then Friday is a Halloween costume party. So don't, you can come as Mr. Clean. You'd be like, have the one about the Mr. Clean.
I get an earring.
That'd be a good one. Or a genie, because you already got it. You don't have to get up like a genie. See that? It's naturally, it's a natural fit. My girlfriend wanted to go as Donald Trump and Kamala, but Nick Raleigh was like, dude, don't go as Donald Trump. Because people always have that. If you do a good job, people unconsciously always remember you as that, psychopath piece of shit asshole. And you don't want that. I'm like, you know what? It's a pretty good point. Plus, it's just it's funny, but well, at least we're in my world, it's a scary thought. But anyways, not to talk about politics here. I realize everybody has their own opinion on things. Dave, my question for you is this: the case that we were going to break down yesterday. What was that case about?
So that was a case where our client was a company called 10X, and what they are is there is in essence a eBay for commercial real estate properties. And so if you own a piece of commercial real estate, you can sell your property the conventional way with a real estate agent or a broker. Or what you can do is you can load the property on the 10X platform and they'll essentially host an auction. And so that happened. And what happened is this defendant who was he owned a bunch of properties. He owned a group of properties in Houston, and he ended up using the 10X platform, and then an auction was held. And there's a number of details, but the bottom line is what the defendant did was essentially manipulate the auction by creating a false persona of someone to bid on the property. I think the idea was he would kind of keep bidding up the property so that someone would ultimately buy it for a really high price. Well, his persona ended up winning the bid, and then he just disappeared. He just disappeared. And so we ended up bringing a lawsuit for fraud, breach of contract, related torts, and we ended up getting a verdict for 6 million and change, something like that. But that was the case in a nutshell.
Got it. And so, where was that case tried?
Orange County,
And so,
California.
did you do a mini opening in that case?
We did a mini opening. Yes.
So when it comes to mini opening, because obviously we have it in our personal injury cases, but what's a mini opening look like, and what's your philosophy on the mini opening?
My philosophy on the mini opening is to not to pretty vanilla mini opening, for me at least. What I find is, because we're right about to start jury selection, you're not getting a ton of the case, and I don't want to provide such a compelling mini opening that we have a bunch of jurors saying, I'm leaning with him, I'm leaning that way. I don't want that. And so I generally provide a pretty vanilla mini opening.
So in this case, what would the vanilla mini opening look like?
It would have been something like, ladies and gentlemen of the jury, my name is Dave Sugden, introduce the group and say, this is a case where we represent a company that hosts auctions, and our allegation in this case is that the defendant breached a contract by not fulfilling his obligations, not being honest as part of the auction process, period.
Okay. And so in voir dire, I know what plaintiff's personal injury lawyers voir dire on, obviously money damages, pain and suffering.
Yes. Right.
Pre-existing injuries, all this kind of stuff. But in a business tort, what do you voir dire on?
Yeah, good question. I mean, on a case like this, what I was mostly, my number one objective was to simply build credibility with the jury. And so I'm giving the presentation where the mindset is jury selection. I'm not excluding. And, and in this case, even though the defendant was a pretty sophisticated investor and owned a lot of properties, and there was an entity, we were the larger company. And so it was the opposite of David versus Goliath. It was Goliath versus David. And so I ask questions about that. And I frame it in a way where everyone likes an underdog story. And this is not an underdog story. This is a case where, I represent a company that's fairly significant. So how do we feel about that? What are our thoughts? And just sort of get people talking about their feelings, their experiences. And then I asked a little bit of questions to sort of foreshadow that this is a case where they're going to have to do some fact finding. In other words, how do we feel about serving on a jury where you're going to almost feel like a detective, where you have one party saying the light's red, the other side saying it's green, and you have to decide, what color is the light? How do you feel about that? And how do we feel about the ability of judging someone's credibility, where they may say something on the witness stand? Do you have the ability to say, I'm not sure if I believe that. I don't think that's true. Just sort of foreshadowing that I think that the other side may try to say things that we're going to challenge. Questions like that.
We talked about the criminal voir dires. I thought one of my better criminal voir dires was my voir dire on lying. Because in a criminal case, somebody on the other side, they better be lying or exaggerating or really mistaken. But I just go with lying, if I believe it's lying. And so that voir dire with that would be like, folks, one of your most important jobs in this case is to decide credibility. That means you got to determine who's telling you the truth and who's not. They may be simply mistaken, but they may have some type of axe to grind, or they may be lying because they have some type of axe to grind that maybe we're not even aware of. And so you're going to have to, decide that. So here's my question: who here? And I said, and by lie, what I mean is an intentional misrepresentation of a known fact in order to mislead or deceive the listener. Does that kind of make sense to everybody? As opposed to simply making a mistake, which is a misrepresentation of a fact, but there's no intent to mislead or deceive anyone. Now, using these two definitions, we all on the same page? So that way it's like, okay, yeah, that makes sense, with those two definitions. Intent to mislead or deceive about a material fact, right? People have a motive to lie. And so then I said, folks, here's my question, which is a refocusing move. Here's my question. Who here has ever had somebody lie to us? And I look around and I see somebody, I said, now, Dave, tell us, how did you know how did you find out that you were lied to?
Yeah.
And then, and because
Yeah.
I'm not really go to the experience first. I'm like, how do we know, right? So we go right to the moment of betrayal, right? That motherfucker, right? So I'm trying to get that from them. And so then what I'll do is I'll make a flip chart and write it down. I said, Dave, how'd you know? Oh, I got an email. I heard, somebody told me something very different that made sense that I trusted, or I found a piece of physical evidence, like a document that showed that they were dishonest, or when it came time to pay me back, they simply told me to pound sand, right? But whatever it is. And so then I would make a list on the flip chart with a line, how I found out, basically, and put number one, that. And then, Dave, why do you think that person lied to you? And, motive, money, control, revenge, right? So we're talking about all these things. So bringing it fresh into people's minds. It's like, folks, there's going to be some lying going on here. So you got to really have your antenna up, because this is your major duty in this court to determine. So then I go through that. And then after I do it with a few people, like 4 or 5 people to get a touch on the experience, I say, now, folks, here's my question. How many times does somebody have to lie to you or to you before you start to doubt their credibility? And then people usually say, a lot of people say one time, and they say one time, I say, okay, who is it one time? And then people don't put up their hands. And I say, Dave, how about you? And of course, you're going to give me the fucking jelly answer. It depends upon the situation.
Yeah.
That's what you're waiting for, right? So when you get the answer, you say, well, here's the situation. So that's a quick reversal. We call it like a spontaneous loop, right? So here's the situation. Let's say a person, I look over and walks into that door, comes across and sits on that witness chair. So I'm creating space too, right? Getting them to imagine the person coming in and sit. And they raise their right hand and they swear under the penalty of perjury to tell the truth. Are you with me so far? Yep. They've been asked a clear and direct question to which they know the answer. But instead of telling us the truth, they decide to lie. How many times in this situation? Now, of course, all those wafflers, those fencers, they all go to one, right? It's no longer, it depends. Oh, is it an important answer? Well, were they embarrassed? Okay, if it was an answer that would cause them some embarrassment, does that justify committing perjury? And if it does, it's like, okay, but you gotta get off my fucking trial. Because then we're okay. It's like, clearly, you're a Trump guy. Clearly, if evidence and facts just don't fucking matter, we can't have a logical argument, right? It's like if somebody, like, you tell them something like, well, you can't believe that's in the news. I'm like, or it's printed. I'm like, you can't believe anything. And so people all agree with that, right? And so one time, but then a situation, because we know 2 things, right? Doctors and police officers get so much leeway from juries. A cop can come. I used to get so frustrated as a criminal defense lawyer because a cop would come into court, lie through his teeth about numerous things, and yet the jury would rely upon his testimony to convict. And it's frustrating because then it's like the world has no balance, right? Because then I would change the fact. I say, well, folks, is everybody at one time? Yeah. Well, how about this? How about if that person that happens to be a police officer? Because I know for a lot of folks, if it's a police officer, they might give them, because police do a very important job of keeping us safe. I mean, you can use a doctor, the same thing, right?
Yes.
Keeping us safe and protecting us. And, when I was 7 years old, I got left home for the first time. Or I don't know, maybe the child, based on how old I was. But, and I said, call 911 if anything happens, right? Call the police. They're there to save you. I said, so there's a lot of folks that might give the police, 2 or 3, maybe, little bit of leeway. And I said, folks, how would you do? How about you? And then people are like, no, actually, I'd hold them to a higher standard. I mean, they're everything. I said, I can understand how you might feel that way, but I have to let you know that if you hold this police officer to any higher standard than you hold any other person, that's simply wrong and in violation of the law. You have to judge them just like you would anybody else. Do you think you could do that? Even though you might think, you set that aside and just follow the law. And of course, yeah. And so anyways, or like, how about a person that claims to be a victim? Because those are people too. They sit there, lie through their teeth, especially allegations of sexual assault. And I'm not saying these are, not big deals, but they are big deals. But they're such a big deal that when they're false, when it's a false accusation of child sexual assault against a parent, and you're the lawyer representing them, and you've investigated till the cows come home, and you know that your client's innocent, that's you want to talk about pressure in a freaking courtroom? That's pressure that, you can't eat, you can't sleep. It doesn't matter what you got paid. It's like it's a singular, endless obsession. That's what it is, but it's about, anyways, I just got digressed, but I just think that's a voir dire for lying.
Yeah, no, and I think it's good too in terms of the idea of showing balance as well. In other words, you're not, both the victim as well as the police officer. In other words, during voir dire, I really work hard to ask balanced questions where it's not just I'm asking questions that ostensibly help me, but rather I really am looking for 12 people that will do their darndest to judge the case on the evidence, follow the law, as opposed to kind of finding a way to put my thumb on the scale. And I think it's really important that one does that to not only build credibility. I think it's essential to build credibility. And so often lawyers are, they can be overly transparent in voir dire, where all of a sudden they think, oh my goodness, I think I can get this person excluded for cause, and they end up cross-examining that juror, and it ends up being very
Right.
uncomfortable for everyone.
Right.
Or that they've said something that makes them vulnerable to cause, and then they end up cross-examining them to try to rehabilitate them, and it becomes really uncomfortable because the jurors aren't exactly sure what's going on, but it's not it doesn't seem it's not a normal conversation. And so I try to do my very best to just be as normal as I can and show that, look, this is sort of a unique conversation because we're sort of having small talk with a bunch of strangers, but I try to get them talking and I ask them to keep talking so we can learn and go from there.
To close things out, just want to like me, you, and Shemek are going to do this presentation on courtroom presentation and persuasion.
Yeah.
And I'm pretty stoked about it because Shemek, he studied for a long time and about this stuff and training and, high performance. And, part of performance is talks about the conscious mind, the stuff that we study, that we learn, right? The questions we ask, that's all deliberate. And it's very important that we have the substance, the conscious mind. But also, then there's the unconscious mind, which is our training. Because once the time to showtime, once you stand up there, like you can't start thinking, okay, am I speaking at a good pace? What's my facial expression right now? What are my hands doing? Where are my eyes at? Am I making right eye contact? All that shit. You can't think about it. If you're not trained, you will default to whatever the crazy shit you used to do before you knew what you were doing.
No, it's so true. Like I remember, as a baseball player in college, people would, we'd work on so many things, and people would ask, okay, so when you're up to bat, what are you thinking about? I'm like, oh, it's super simple. Watch the ball.
Right, the ball.
The ball.
What else could there possibly be?
That's like it. Just watch the ball. And everything else takes over. And that's why I see the parallels, because trial lawyers, we've all had that moment where it's the equivalent of sort of being in this flow state where you realize I'm not thinking about myself. What I'm really being able to be mindful at the same time of what is the jury picking up? What is the witness saying? And you're able to sort of slow the thing down to component parts without overthinking it. It just sort of is coming natural, and it's the byproduct of obviously experience for sure, but to a large extent the preparation and the deliberate practice you've done to lead up to that moment. I mean, people, a lot of times you'll see lawyers and they think, oh, they're so quick on their feet. Maybe, but they're also prepared, and they've
they're great because they're prepared because they've seen it before. Right.
Yeah.
But like the third component is the self-image. So we got the conscious mind, the unconscious mind, and the self-image. That those three things come together for performance. Because without confidence, you can't. I don't care how great your materials are. Without confidence, there is no performance. There is no delivery. Because all there is fear that separates us.
And I think that there ends up being sort of a paradox where, on the one hand, you have to do all this work so that you perform well. And then when it comes to your actual performance, the last thing you should be thinking about is, how am I being perceived? If you're concerned about how you're being perceived, I promise you won't perform well. Whereas if you focus on, is the witness being understood? Is the witness communicating? Your focus will be not on yourself, but on the witness and what the witness is saying. And without thinking about yourself, you end up having a much more natural, compelling performance.
Right. And, I used to think like some of these great trial lawyers were sociopaths. I think that they are, Because like, I'm like, you have to get up there and you have to look at those people and be like, these people love me. They freaking love me. They're so glad that I'm standing here and they get to hear my voice. Every one of them just love me, and I think that's the power that the great ones have is they get up there and they get energy from the crowd because they believe that. And people are like, well, is it true? Does it matter? Does it matter if it's true? No, it matters if the person truly believes it, right? And then they get the energy from the crowd and the crowd, and they get connected because at the top, the whole game is connection. That's the whole game. When you walk, I mean, the evidence, you obviously have enough evidence to go to trial to win because you survive summary judgment, right? So once you walk through those doors, it's the jury, the connection. And that's what the great ones. And that's the greatest thing I learned from 3.5 years of sitting in a chair on Zoom is that it's a game of connection and it's a game of very small micro movements in inches. That is the difference, especially in this game of winning and losing. Like, you know what I mean? It's such a fine thing. That's why it's so important to train. And that's why, I truly believe this is the greatest time to be a trial lawyer because it's all there. Everything is there. Like the stuff you're putting out helps people so much because those are scary things, especially for all lawyers. I mean, I've been doing this 30 some years. Trust me, I can't wait. Like I'm going to prepare so hard on my evidence and my objections and stuff for my next trial because I want to look confident, right? I want to be confident. I want to be credible with the judge. And I know that, like you said, if I'm not prepared and that won't happen. And it's just a matter of, but doing the work, more importantly, knowing what work to do. I mean, because now we got the training, you got your class, I got my boot camp over here, that, it's evolving too. Cause I got like a 4-day trucking, performance master class with Joe Freed coming up in May for 10 students. That's gonna be the greatest learning experience ever. Cause like Joe Freed is like such a trucking guy and such a great guy and a great teacher, but just have a small group of people working on the same kinds of cases for 4 days, plus with, weeks of preparation via Zoom. So everybody's prepared. Everybody knows what the materials are. They've already started practicing, thinking about their opening statements, their cross-examinations. They get here, get to practice and get the muscle memory going and get the ideas going because as they, put it, as they relive their cases, they really get to know them so much better when they're performing them. Because perform them, they have to relive them. And the more they relive them, the more that the story's embedded in them and the more they believe because it's all about believing, which is the key component. So, and then there's, TLU on demand, and other learning things like, Trial Guides has a lot of great materials and books on it, but, books I find it kind of hard to really connect with because there's more theory, so much theory, whereas like videos of people performing, at least it's not as good as getting up yourself and performing, but at least you're getting an idea what the performance looks like. Whereas books, you just have to try to imagine, yourself or somebody you think is a good lawyer doing the presentations that they're doing. So, but this is the time. This is the time to be a trial lawyer. And frankly, in places like, TLU with so many great trial lawyers coming together for 4 days and just, teaching and sharing information and collaborating again, especially like these it's like these master classes like Michael Hill, who's out of Cleveland, Ohio. All he does is elder abuse, and he did a master class for 2 days in Huntington Beach last year, and there's like 20 people in it, but now they have their little like when the smart people get together and really focus, like the creative stuff people come up with is amazing, and it's just real exciting. So Dave, our time has come to an end here. I'm going to see you in approximately 1 week.
Yes.
And it's going to be pretty awesome. I'm, super stoked for it. All the people that are coming together, you're going to make so many new friends. It's crazy how many new friends you're going to make. I mean, it's crazy how many people you make.
It's going to be great.
Like the personal bios and stuff, and people read your personal bio and you read other people you meet, and then it's like you get connected to people, like all the students that are in your little groups, a combination of experienced lawyers and law students. It's pretty cool, especially because your group's on Thursday, so all those people get to meet, hang out, you get to know them all, and then you'll see them with the next 4 days. So that's kind of
I'm super excited. It's going to be great.
It's going to be great. All right, Dave Sugden, good to speak with you, and I look forward to seeing you next week, and I look forward to collaborating and creating a really cool class to teach these fundamental skills that people ignore.
Thank you, Dan.
Ready to train with the Titans and set records with your verdicts? Register for our live conferences and boot camps at triallawyersuniversity.com. Start getting your reps in before the big event by going to tluondemand.com to gain instant access to live lectures, case analysis, and skills training videos from the trial lawyer champions you love and respect, as well as pleadings, transcripts, PowerPoints, and notes for a roadmap to victory. Join the group that continues to get extraordinary results. Trial Lawyers University, produced and powered by LawPods.